Hi, good afternoon. This is immigration attorney Assad Hafiz. I practice out of downtown Sacramento, Ninth Circuit. I can be reached at 916-836-5755. I can be called or texted at that number. Feel free to give me a call or a message for any of your immigration related questions. Now, I'm just here at the office taking a little break here. I'm filling up on some coffee and wanted to talk about a new decision regarding motions to reopen. You may have heard that it is possible to reopen an immigration case, an immigration court case, when there is already an order of removal. There's already a deportation ordered. Someone might have re-entered the United States and wants to reopen their matter based on some kind of good justification. And here we go. This is just going to be a little fun. I'm going to have some coffee going while we're doing this. Let's see how this works. We're just going to kind of keep this a little fun and informal here. Okay, so the name of this case is called Fernando Mendez Gonzalez versus William Barr. This case was heard in the State's Court of Appeals, Ninth Circuit in San Francisco, California, and it was decided July 11, 2019. So basically, let's go over what this case is about. Let's see if this coffee works. Here we go. Here we go. Hey. Right on. Okay. There we go. All right. So, what I want to do is, this is a case decision. This is where Mr. Fernando Mendez Gonzalez filed to reopen his court case. He was previously deported to Peru. He's from Peru. He illegally re-entered. He entered without inspection the first time, and he did so a second time after his deportation. Why was he deported? He got a conviction for illegal possession of cocaine. That was a conviction that he had. Why was he trying to reopen this? Basically, he filed through his attorney a motion to reopen because that conviction later was vacated. So basically, the courts found that he was no longer guilty of that offense. How did he do that? Through his attorney, had it vacated because he was not informed, did not get notice that by pleading into this conviction, he would suffer some very harsh immigration consequences. So, wanted to share that as some of the history here to this case. But he files the motion to reopen after he illegally re-enters through his attorney. He wants to have it heard by the Board of Immigration Appeals, the BIA, under their sua sponte authority. Now, there's a lengthy history to this case as well, and I'm going to try to make it as simple as I can. I'm going to put some cream in my coffee just to keep this a little fun. Here we go. Put some cream in the coffee. All right. It'll keep me powered for throughout the day here. Okay, so there's an area of the law, and it changes in the middle of all of this. So the first time around, they denied his motion to reopen sua sponte, and the court refused, the Ninth Circuit Court of Appeal refused to review what the board decided, which is, no, we're going to deny your request. The immigration judge denied it. Then he appealed to the Board of Immigration Appeals, the next level. They denied it, so he wanted to take it to the Ninth Circuit Court of Appeals. Nope, they denied it. They said, we're not going to review it. The board has tremendous discretion to review or to deny review to these motions to reopen under its sua sponte authority. What does sua sponte mean? It means of its own motion. They have that discretion if they want to try to reopen or not, if they want to review, approve, or deny these petitions. So anyway, Ninth Circuit refused then. Ninth Circuit did the review later. When? After there's an area of this law called the post-departure bar. So he had already been deported, right? But he wants to reopen it. Well, each jurisdiction, I'm in the Ninth Circuit, there's other circuits as well, they have different views on this. Ninth Circuit now, it changed from that time period when he initially was deported and he sought his first review. It changed later. Previously, the post-departure bar was in effect. He was already deported. You're outside of the country. no, we are not going to consider your motion to reopen the immigration court case. We're not going to do that because you've already been removed. The post-departure bar applies, and that's under a case called, the old case is called Matter of Amarendis Mendes, BIA 2008. Well, that law changed in the Ninth Circuit once Reyes Torres versus Holder was passed by the Ninth Circuit 2011. Aha. So he tries to get this reopened after that change of the law. Now, another problem here too, ultimately he ended up losing. So the Ninth Circuit ended up denying his request. They ended up upholding that the BIA has this tremendous authority to review and deny petitions to reopen, motions to reopen under its sua sponte authority, of its own motion. So the other thing that was at issue here is there's an exception to the 90-day deadline to file, because he filed this much farther after. He tried to argue that he has exceptional circumstance, that he has a very good reason, basically, in a very informal description. He had a very good reason, an exceptional circumstance, why he did not file in that time period. So that is partially what was going on here as well. He argued that basically his conviction being vacated was an exceptional circumstance. The court did not go for it. So the court ended up denying it. The IJ denied it, the BIA denied it, and the Ninth Circuit ended up denying it. All right. So ultimately he ended up losing this. There's another significant part of the discussion in this case where the attorney brought a lot of court decisions in support of the argument, trying to show that there was a settled pattern of adjudication, but a lot of those cases were unpublished, and basically that means that they're not put out there for the public to look at as, hey, this is the actual law. No, these were quickly made decisions, and they're unpublished, they're unreported, they are not intended to be citable authority under the laws of the United States. So they rejected his argument that he had some authority that should be followed. Basically, the petition for review was denied by the Ninth Circuit, and I wanted to go ahead and cite this because this is a very interesting, fascinating area. He was able to file a motion to reopen, have it considered by the board, but they denied it, and then the Ninth Circuit denied it. But he was trying to argue he had an exceptional circumstance. The law had changed. He overturned the conviction. Nope, didn't go for it. But this is a very juicy area for motions to reopen. A lot of individuals get a deportation, an order of removal, and they may leave the country, then they come back later and seek an attorney to file something like this. So this is a good area of the law to know. Just want to share that with you. My name is Asad Hafiz. I'm an immigration attorney. I practice out of the Ninth Circuit, California, from downtown Sacramento. I can be reached at 916-836-5755. Catch me there, phone call, text message, or feel free to message me on LinkedIn, my website, legalstrategiescompany.com, or on my Facebook as well. Thank you so much for your time, and talk to you soon. Take care.